Hi, everyone. Sorry to kind of torture you with my voice a second occasion. Taking a leaf from the first session where we spoke to the bidders and bidders in very competitive processes, and a common thread of what they saw was a micro issue of the insolvency process was symmetry of information. That often bidders are going into deals which otherwise, of course, meet all the fundamental requirements, but they don't have access to enough data. And data, one cannot emphasize enough, is literally value or valuation. Because currently, of course, your assumptions, you're going into an asset, obviously an asset where there could be a fair bit of, disharmony, because IBC kind of also in that sense is litigious and all of that. And the last thing the bidder wants to kind of be confronted with is not to have access to data, let alone not be able to preserve it going forward. So in that setting that as the context of being the thorn in, more than one bidder's and possibly most bidders' flesh, I'm very happy to have Jayant here, who'd possibly, come in a tad too late into the process, but has to do that dirty job of kind of helping those bidders thereafter recoup the asset and make that asset the quality that, that's operable, and that's what the bidders have paid for. In that context, I think, Jayant, I'm sure you've been doing this for a while and not always with happy outcomes, but somewhere there. I think my first question really to you would be, in a traditional M&A which is consensual, there's a fair bit of information leakage, lack of information gathering. How do you think it will be even more complicated in an IBC process, especially, in some of those deals that we see, where there are actually, a fair bit of confrontation happening between the existing incumbents versus the incoming? So how different do you think is the situation in the IBC process?
Perfect. Thank you so much. And good afternoon, everyone. Sorry to be the guys between lunch and you. But, I think this was an area that I've been speaking about a bit. And, thank you so much for having me here for this session. So to answer your question, I think it's important to contextualize it in when we look at an insolvency scenario. What are the things that happen when you are when a company is going down that route, or when an asset is going down that route? Firstly, there is a fair bit of angst. There is a bit of angst as far as your service providers go. And there are real-life examples of someone who was managing a company's financial reporting system who pulled the plug on it because they had not been paid or were threatening to pull the plug on it. There are employees who are disgruntled. There are employees who are nervous. And there is some amount of movement out of the company of these employees, for a variety of reasons. Either they've not been paid in the past, or they, see the company going down. And, there is a lot of knowledge and a lot of information that resides with such people. So from a operability perspective, if I was to look at it, what could possibly get impacted is your financial reporting system. It could get, other things that you have outsourced. So it could be stuff like your payroll. It could be things around your IT systems, which is taking backups of historical data. And if I just go back, you see the amount of money companies are spending today, regular operating companies are spending today on IT. You are running the risk of that entire aspect of an asset going out of whack. So you have, you'll have your entire story around your financial reporting systems, outsourced services, employees who are custodians of knowledge or information about how past transactions have been done in the company, who are leaving. A lot of them, if they've been in a particular industry, will possibly go to another company in the same business. So you run the risk of competitive data of that company going. Plus, you have this whole plethora of information which is lying on other technology systems within the company. Now, for the purposes of discussion, if I just split it up into two. So there is structured data, which is where your numbers are. So it is your financial information. It is, possibly sales data, it could be your accounting information, which is a little more structured, which gives you one perspective, which a lot of resolution professionals would sort of rely on. But there is also the entire unstructured data aspect of it. So which is your emails, which is files, business proposals, contracts, which possibly are languishing somewhere in the systems that no one knows about, which could come alive, undisclosed liabilities. There may be some action that has been taken, which has been lying dormant for a while, but eventually, the counterparty can wake up and say that, look, I had this obligation or contractual obligation with the company. There is a breach of this. So how do you get a handle on all of these aspects? That is where the management of data in an insolvency scenario becomes very important.
Only to kind of complicate the situation a little further for you is, one is, of course, this is resolving collection of data within the entity that's part of the resolution. Often what you will see in the way Indian companies are structured, the data doesn't even sit in the company that uses or operates on that data. So the ownership of the data could be distinct in that sense, whether it's your intangibles like your IP, your designs could actually be residing in an entity that you don't even have access to in the IBC process. So one, to come down to ascertaining the ownership, and thereafter to be able to have access to the ownership should be another challenge that you could kind of highlight to us in the context of general M&A and how you see that playing out in the context of IBC.
Absolutely. So if you look at it again from the context of, let's say, a conglomerate, what you would have is, there is possibly one subsidiary that's gone into insolvency proceedings. There is a fungibility of resources. So there could be people who are sitting with a parent, but who are operating in the subsidiary. There is a lot of content which is created. Now, let's assume there's a big power plant. There are drawings, there are process-related IP that is created, but it does not sit with the subsidiary, which is under insolvency proceedings. And a lot of times you don't know about this till the final sale has happened, right? So how is it that you can move a few steps ahead and look at this even before? Because, then at least you're bringing a quality asset to an ultimate buyer. Because at that point, someone is going ahead, buying it, and then they suddenly discover there's a whole, set of things which they assumed would be part of, what they've bought, but which is not there. So how do you deal with that aspect also, like you rightly said, is extremely important. And there is a discovery process that needs to be done around that. And in most cases, that discovery is only going to be possible if you look at what I called unstructured data. It's not going to come out of a financial system. It will come out of looking at possibly email communications. It will come out of looking at intercompany contracts. That is how you will uncover something like that.
So I think kind of going into, this could be an issue also with the kind of bidders in the process, right? I mean, as we heard from our first panel, there isn't enough money in circulation in India to meet the requirements necessarily of the IBC process, and therefore we need to raise money overseas. Now, overseas bidders, in addition to having issues with operable and capital-intensive data, are also interested in compliance data. And when I say compliance, it's not necessarily your payroll compliance, but say compliances with PCA issues, compliance with laundering issues. So that kind of brings in, because that becomes a prerequisite to acquisition. It's not really a prerequisite to operations. But for them, with zero tolerance laws in the jurisdiction that they're placed, it's actually a prerequisite to acquisition. So that context where India has poor electronic data management, and also this is the sort of data which is most vulnerable and prone to destruction. How would you kind of approach going into a company to kind of gather this kind of compliance data?
Sure. So my personal view is that the moment a company is going to go down a route of insolvency, the first thing you need to do is go in and preserve all the data, because you will not have access to that data if it's destroyed. So the first thing you need to do is take control of all that information, whether it's structured data or whether it is data lying on email servers, file servers, cloud, wherever it is. That data needs to be preserved. At least you have the option of having access to that data at a later stage. If you do not preserve it up front, there is no access to that information. So, no matter what happens later, you are only going to have, what's available on the servers, post any destruction, wiping, someone taking data out, which is going to be available to you. So the first thing you need to do is go ahead and preserve. in terms of prioritization, that is an activity that can be done subsequently. If I want to go ahead and look at, let's say, from a compliance perspective, whether it's a PCA, whether it is if there's a international angle to it, whether it's an FCPA, whether it is competition, whether it is income tax, or whether it's any other taxation related matters, at least those you can go ahead and see what the context of certain decisions taken at a particular point were, if you have that data. Then life gets a little more complicated when I look at the fact that most companies will have a backup system. So there will be data that is going to be lying on backup tapes, possibly offshore at some vendors, right? Which again, neither the buyer initially has access to, nor will you as a resolution professional have, or even as a service provider have access to. So you don't even know what sits in that information. You're going ahead committing funds, you're going ahead and buying an asset, but you have no idea of what is it that you're buying, where you may end up spending a lot more trying to resolve those issues and a lot more time, not just money, rather than focusing on building up the business, which is your primary reason for investing in that business or buying that asset. Again, to complicate it even further, you have emerging laws. So now you have something like a GDPR in Europe, you have a personal data protection bill that is being talked about. Now tomorrow if someone comes back, you've bought an asset and someone comes back and wants to exercise the right to be forgotten. As a company, and if all that has been talked about in that data protection bill finally turns into an act, you have a data protection authority that you will have to go back and confirm to that you have removed data related to a particular individual from your systems, right? So, all of these things are only possible if you at least have that information, or at least you know what that information is, right? We've seen situations, and I'm not going to take names here, but we've seen situations where we had an overseas company acquiring an Indian company, and I'm not going to talk about the sector because then it becomes super obvious. But you've had the issue where they came back and said that, look, some of these exposures that the company had, or some of these liabilities that the company had, they never disclosed to us, right? And finally, it became a big mess. But yeah, that's the ground reality. That's the environment we are operating in. So
assuming we kind of skip through the first loop, and there are of course assets, especially the most sophisticated assets, which are on the block and only on the block possibly because of mismanagement, but otherwise have systems in place. And those are good assets, and those may not be as many. There'll be far and few in between. We may actually have assets which don't even have sophisticated record-keeping measures, don't necessarily have, may have obsolete technologies that they use. Now, in that context, if there is an acquirer who's coming in with a whole different sort of data preservation system, how difficult will it be for him to preserve that data whilst kind of in parallelly integrating that data? Because the difference in quality of technology could also kind of impact the preservation systems that the acquirer has. It's always better if they're all good, but there'll be somebody who's so good that they can't deal with the bad. And then what happens in that sort of scenario where you have to kind of merge technologies?
One needs to be practical about it. One needs to, be pragmatic about it. And I think at the same time, you also need to sort of figure out where your risks lie. Right? Now, most companies, and if I look at the M&A scenario that I've been part of, there is no rush to integrate, right? So especially your information systems, your financial record systems, emails, it may spend some time separately. They may spend some time running two parallel setups and then finally integrate it. But that still does not take away the obligation. Now, if I just take tax laws, for example, and you and I were talking about it, there is still that obligation to retain data for 7 years. So even if I'm looking forward and I say my integration can happen 2 years down the line or 3 years down the line, it still does not absolve me of my obligation to retain certain amounts of information, right? Tomorrow, if someone comes in and asks questions, at least you should be aware of the fact that there is that information available in X system, and you don't need to go through, RSTUV, X, Y, and then finally get to Z to be able to identify it, because there's a cost attached to it, there's time attached to it, there's effort attached to that.
So Interestingly, also the regulation has, of course, now also said resolution professionals who've had access to data also have an obligation to preserve that data. So, I mean, in an ordinary scenario, resolution professionals' engagement should end with the end of CIRP, but this is an ongoing data. Like you say, there's a cost attached to it. There's also, I mean, a resolution professional is dealing with all kinds of assets. So what do you think would be a challenge for an intermediary, who otherwise is on a limited role to kind of preserve, data of this kind of thing, right?
So the fact is, data can mean anything. So even when I say, there is an obligation to retain data, it could mean different things to different people. So I think the first thing we need to do is actually get clarity on what is it that you're retaining. Is it what was relevant to your work, or relevant to what you've decided, decisions based on, or made decisions based on? So that is what needs to be potentially retained, right? There are places where you will have paper documents. There are, which have their own life in terms of, or their own, let's say, space that they take to retain. You will have electronic data. My personal view is that you need to step back. You need to look at the fact that, yes, I have to retain it. You need to think of, okay, 8 years hence, how am I going to destroy it? So there is a whole record retention story that comes up there. And you need to also create a justification as to why you are retaining certain types of information. From a pure risk management perspective, I need to know why I'm retaining certain things. So that's from a resolution professional's perspective. From a company's perspective, just because of the amount of data that's getting created by the second, it may be a tougher task for them to, comply with such obligations, such queries.
I think the other question that, at least us as M&A lawyers kind of keep getting confronted with is, often we've kind of, when we've gone into especially in the resolution plan context, we've often kind of focused on the hard assets, the assets which are on balance sheet assets, but we've not so much, and data would largely qualify as an off-balance sheet asset. But, do you see clients when they go in blindsided, because, often also IBC doesn't enable you to access data of, say, subsidiaries, because they've clearly said subsidiaries' assets are outside the scope of the parent company. So in that case, have you seen clients kind of come to you and say, assist me with kind of valuing the blindsided aspect? Like, I also want to factor that into my valuation, because not necessarily in India, recourse, legal or otherwise, is really the solution. So do people kind of come to you guys and say, help us add a number to the data that we can't see?
I wish they would, because I don't think that conversation has happened too actively. So I think it's been more in terms of what is immediately required to be done. And I gave you the example of a scenario where there was someone who was managing the financial management system who was pulling the plug. And in that case, of course, we had to go in and preserve that entire financial records and try and restore those. But those are sporadic. We are looking at, what is it that my current role requires me to do? So if I'm a resolution professional, what is it that I'm supposed to do immediately, right? So that's where a lot of focus has been, and fairly so, because that's really the ask of them. But if you look at a broader context, what you're saying is actually a fantastic thought, that finally when it is being disposed of, you are also giving a substantive bit of information which covers the history, context of again why decisions may have been taken. You are looking at various forms of contract, circumstances under which those contracts were entered into. So besides what you do in a forensic fact finding also, which happens in a lot of these cases, at least the new owner of that business has that history that they can refer back to, which permits them to be able to take certain kinds of decisions, which at least allows them to take that business forward rather than perpetuating a set of issues which may have existed pre-insolvency.
This is really now me kind of trying to capitalize on being allowed on the stage. But, another thing that we've seen where we're running the process, so where I'm on the other side of the table, not acting for bidders, but, for the process runners, often you will you will be looking at assets with a lot of proprietary information, all of which, if disclosed to multiple bidders, who could also be your strategic competitors in the market, and one of them is going to be successful, I may be inclined to holding back information, right? Because I'm not necessarily, my only recourse thereafter will be to enforce confidentiality under my RFP, etc. So often, I think you may also kind of see that, information, at least in the initial stages on proprietary information, may be held back. And, they say only a successful bidder can get it. So, there are sensitivities because this is a competitive auction process. So how have you seen bidders deal with that and, otherwise M&As? Because I'm not sure there'd be precedents of that in the IBC space.
No, so I think you're completely spot on. You may not want to disclose that to everyone. But at least, you can say that this information is available. It does add value to the quality of asset that you are talking about, or, which is there on the block, firstly. And secondly, yes, it is IP. It is something which the new owner should own. As long as that IP is owned by that business or that stressed asset, that IP should belong to the new owner because, it's a whole, well, it depends on the nature of transaction, right? I mean, if it's so it makes a lot of sense that the IP at least is made available to the new owner. The problem is at times we don't even know whether that IP is available, who owns that IP, right? So, once someone is taken over and then they suddenly figure out that, there's a huge license fee that may be payable to someone because of a plant or a process, that is being used. So, so those mitigating factors is where some amount of discovery is useful for, at possibly initial or at least in parallel to the resolution process.
So, very interesting, Jayant. I think I would kind of say the last difficult question for you is all of this is difficult to start with, and it gets more difficult if you're a regulated industry, right? So, if you're going into pharma, you're going into, financial services outside of the IBC, but if you're going to regulated industries where the data is, proportionately linked to liability, then that kind of complicates things. So do you believe that there has to be an institutional mechanism under the IBC that assists you with the fact-finding? Because this is non-negotiable information. It can't be settled through valuation, right? So do you want, in terms of if you were allowed to kind of look at what the system should offer, what is the sort of protection do you think the code needs to kind of factor in when looking into these items?
So I think the code needs to take cognizance of the fact that, we keep talking about it, data is the new oil, companies are spending so much to, protect their information and data. It is a reality. Some companies do it better than the others, right? So I think even from a code perspective, there is an aspect which possibly needs to be built in where you do keep data preservation as an activity upfront, right? Because through the resolution process, a lot of things can change. When it comes to the sale, there's a lot of things that can change at that point. But at least you have that information available should it be required. And it's, again, the idea is to make sure that at the end of this entire activity or process, you have a company that can stand on its own feet or at least, operate profitably eventually. Then I think the obligation is also there to make sure that all the wherewithals are provided to make that possible. Now, whether it is done from a code perspective, whether it is done from a lender's or whether it's done from a professional's perspective is I think, a matter up for debate.
Thank you so much. Thank you for bearing with us and hope you've enjoyed your session. Thanks, Jayant. Thanks a lot.
No, thank you so much.